Welcome everyone, this is Amer from U-Council. Today we'll talk about frustration of an employment contract and how does the frustration of a contract affects an employee's rights on termination or on the frustration of contract in Ontario. Frustration of contract is a specific legal term. We'll explain what it means and then we'll explain the impact of the frustration of a contract on employees. Before we begin, we'll provide you with our usual disclaimer that this course is not legal advice. So if you have any specific questions, you must contact a lawyer or a paralegal. So what is the frustration of a contract? Frustration of a contract is dependent upon the occurrence of an unforeseeable event. That's the first item that you want to remember. It has to be an unforeseeable event. And then the result of that unforeseeable event is that one or both parties are no longer able to perform the fundamental terms of their contract. One party or both cannot perform their fundamental duties that were required from that contract, and I'll explain that a little bit more in an example. And by virtue of that, if a contract is frustrated, then both parties are relieved to perform that contract, and then they are relieved of any liability. So they're not liable to each other for the breach of the employment contract. That's why it's called the frustration of a contract, because the employer, the contract can no longer be performed without the fault of either party. So let's go back to this idea of the fundamental terms of the contract cannot be performed. So I'll give you an example to explain that. Let's say an employee was employed with a company and his job or her job was to drive a forklift in the warehouse of that company. That was the basic duty of that employee. An employee ends up in an accident and the result of that accident is, let's say that the employee becomes paraplegic or gets the kind of injuries that he's no longer able to drive a forklift for the rest of his or her life. So in that situation, because the fundamental job was to drive a forklift, the employee can no longer do that. The employer can claim that the employment contract is frustrated and employee is not entitled to any common law termination rights of any kind, or cannot sue the employer for any damages that relate to termination. So that is a scenario in which the employment contract may be considered to be frustrated. So the employment, I want to mention that all of the items that I have mentioned above with respect to frustration of any contract, whether it's commercial or otherwise, they apply to employment contract equally. What you want to remember is that if there is a dispute about whether a specific employment contract is frustrated, the burden of proof is on employer. This is a bit of a technical thing, but important one. So burden of proof means that it is an employer's job to prove to the court, to prove to the judge that the employment contract is indeed frustrated. It is not an employee's burden to disprove that there was no frustration. So it's a technical thing, but an important one when you are at trial and dealing with this issue. Okay, so what are the consequences if an employment contract is frustrated? I have mentioned some. Number one is that the employee will no longer be entitled to any common law rights on termination, which is an important one, because if you have heard my previous lectures, you know that if an employee is dismissed from employment without cause, he or she may be entitled to common law notice, which is a significant amount of money or which is a significant amount of length of notice that allows an employee to get back on his or her feet and look for another employment. So common law rights on termination are no longer available, and also employee is not entitled to any other damages that may flow from the termination of contract under common law. What the frustration of contract does not change is an employee's statutory termination and severance pay, and this is important because these rights remain intact. And under Employment Standards Act in Ontario, the legislation specifically provides that if an employee's employment contract is frustrated because of injury or illness, the employee is still entitled to termination and severance pay. So the two items that are depleted are the common law rights on termination and any other common law damages relating to termination, but what remains intact is statutory rights on termination. Let me give you some examples of when an employment contract is frustrated so you can understand the application of this concept and some of the common ways that it happens. One common example is obviously death. If an employee passes away, his or her employment contract is frustrated, and so he or she or his estate or her estate is no longer entitled to common law notice of termination. Disability is probably the most common situation in which an employer can claim that an employee's employment contract is frustrated. It could happen by virtue of a statute if government passes a legislation which because of the application of that legislation, that statute, one or both parties are no longer able to perform their contracts, then the employment contract can be frustrated. There could be some catastrophic events that are unforeseeable, some pandemic that may occur, and that may render one or both parties unable to perform the fundamental terms of the contract, and that may happen and then make the employment contract frustrated. But the most common example and the most common occurrence of the frustration of an employment contract is relating to disability, and I'm going to talk about this in a bit more detail so you can understand that concept. Some of the examples in which an employment contract is not frustrated: loss of profit. So employer cannot come to the employee and say, the company was expecting $20 million in profit and we did not make any profit, or we suffered a loss and therefore we believe that the employment contract is frustrated. That's not an unforeseeable event, and so it does not render an employment contract frustrated. Other economic challenges are also not a reason for an employer to claim that an employment contract is frustrated. Another part that you want to be clear about is that when a court finds that an employment contract is frustrated, it must be such that the fundamental terms cannot be performed at all. So if for some reason it makes it difficult for one party or the other party or both parties to perform the fundamental terms of the contract, but they're still able to do so, or it becomes more onerous to perform those duties, that does not mean that the contract is frustrated. So let's go back to our example of the forklift driver. If in that situation, let's say that the driver was not completely incapacitated to drive, but let's say because of the accident he or she got an ankle sprain and it's causing a bit more difficulty. It takes her longer to drive that forklift and do the task that could have been done ordinarily in shorter amount of time, then that's not a sufficient reason for an employer to claim that the contract is frustrated. So just because it has become difficult for one party to perform the fundamental duties does not mean that the employment contract is frustrated. Let's go to now disability, which is an important part of this lecture. When an employee is disabled temporarily or permanently, how does that relate to the frustration of an employment contract? So the key concept that you want to take away with respect to frustration of contract and disability is that when court is reviewing whether a disability renders a contract frustrated, then court is looking at the permanence of the disability and not its duration. So that's the key concept that you want to carry with you. It's the permanence of disability that makes the contract frustrated, and not the length or the duration of that disability. So some of the factors that court considers, the duration is obviously one of the factors that court does consider, and I'll explain that in a bit more detail further. But the key thing is the medical prognosis, or what are the doctors, and the court will review the evidence, the medical evidence, and what does that evidence suggest? What does that demonstrate? Is the disability of a nature that is permanent, that the employee can never recover and then perform his or her fundamental duties? Then in that situation, even if it's been a week or 10 days that the employee was disabled, it could be argued that his or her employment contract was frustrated. So permanence of it, what are the prospect of recovery? Is there any reasonable chance of an employee recovering from his or her disability or illness and being able to perform the fundamental terms of the contract? then in that situation, if there's a scope, there's a chance, then the duration is not that much of a consideration. The court will not find that the employment contract was frustrated. Obviously, the degree of incapacity, how severely that disability, that illness is affecting the employee's ability to perform fundamental duties, that is a consideration, and the length of disability is also a factor. So going to the length or the duration of disability, we have seen cases where an employee was disabled for 2 or 3 years, but the disability was not of a permanent nature, and the court found that just because the employee was not able to perform his or her duties for 2 to 3 years and was on long-term disability, that did not mean that the employment contract was frustrated, and court rejected that argument. I do recall, I believe there was one case in which the employee was away from duties for about 7 years, and the employer contended that this was a long enough period for an employer to claim that the contract was frustrated, and court rejected that argument and said that there was a prospect that employee will be reasonably able to recover and come back to work, and so the employment contract was not considered to be frustrated. So the key item that you want to remember, as I mentioned, is that it's the permanence of the disability, the illness, that is being considered here. If there is a reasonable chance that the employee will be able to recover and get back to work, then it doesn't matter whether it takes 2 years or 3 years. The duration is not that significant. It is significant, but not to that extent. It's one of the factors. So one thing that, in conclusion, what do you want to remember? The key thing that you want to remember with respect to frustration of employment contracts is that determination of whether an employment contract is frustrated or not is very fact specific. In every fact situation, there will be different circumstances, different nature of illness, different issues, and so it is not easy to draw conclusions based on what happened in another case. The principles are the same, but the facts may be different. And so if you're unclear about your own circumstances, whether your employment contract is frustrated or not, you will be better off discussing that with an employment lawyer to make sure that you're not making any assumptions about the frustration of your employment contract. If you're an employee or if you're an employer, you want to make sure that you consult with an employment lawyer and understand whether you as an employer can claim frustration of contract. You also want to remember, as I mentioned, that in Ontario Employment Standards Act, rights of termination and severance pay remain intact even if an employer has claimed frustration of contract. And in this regard, let me give you an example of a recent case. I believe it was a 2015 case where an employee was employed and he was diagnosed with a terminal cancer, and because of that he proceeded on disability, and while he was on disability he passed away, and an employer refused to pay any severance or termination pay, claiming that the death of that employee frustrated the employment contract. And as we know, the death does make the employment contract frustrated. But the court disagreed with that. The state of that employee sued the employer for the rights on termination, and the court agreed with the estate on grounds that, and this is how the court distinguished. What court found was that when the employee was disabled and he was diagnosed that he was now terminally ill, and so there was no prospect of him ever returning to work because he was expected to pass away, court found that that specific time the employee's employment contract was frustrated at that time, and because it was frustrated at that time, that allowed the application of Employment Standards Act, which specifically says that if the employee if the employment contract is frustrated because of illness or injury, in that case the termination and severance rights remain intact, not death. And so the death occurred after the frustration of contract, and therefore the employee was still entitled to termination and severance rights. So that's why you want to make sure that you understand the specific circumstances of your case and then apply the principles of frustration of contract accordingly. I also mentioned that it's the employer's burden to prove that the employment contract was frustrated, which is a technical issue but an important one at trial. And then what I want to mention is that common law rights on termination, as you know from previous lectures is an important right, and so if an employer is improperly claiming frustration of contract, you would like to challenge that because your rights on termination, or common law rights on termination, could be significant, and so it is important to dispute the frustration of contract if you can. This is our contact information. Please feel free to provide your comments, and if you have any questions, we'll love to hear from you, and thanks for watching.